Is an Erasmus Plus strategic partnership funded program gathering European universities, jurisdictions, bar associations, companies and startups around the legal questions raised by the development of autonomous systems within our societies. The idea of conducting mock trials involving academics, both from the legal and the engineering areas, law students and future engineers, courts, law firms, companies evolving in the field of new technologies, started here in Lyon, France, more than 4 years ago, thanks to the support of Lyon Administrative Court of Appeal, practicing lawyers and a few companies, and lawyers and bar associations. We realized soon how this method allowed cross-fertilization between the involved partners and the different persons taking part in it. The then named Future of Digital Technologies Law Clinic soon also became a working group within the Digital Law Special Interest Group of the European Law Institute. These were the first bricks of the current EU network with our great partners, Università del Piemonte Orientale in Italy, Radboud University in the Netherlands, and Łódź and Jagiellonian universities in Poland, with also associated partners, Lyon Administrative Court of Appeal, INSA from Lyon, Lyon Bar Association, and especially its incubator, the company Transpolis, a leading actor in the field of autonomous vehicles, and other startups. Today's dissemination event should have taken place in Lyon last April, but due to the pandemic, it had been postponed to October, and here we are. Though we would have loved to welcome you all to our beautiful city, by the way, with a beautiful sunlight today, we are delighted to welcome you by distance and to welcome the various speakers of the two panels. Professor Pichonaz, Vice President of the European Law Institute, Professor De Elizalde of EA University, Professor Cluzel-Métayer of Université de Lorraine, Mr. Barbier of Transpolis, Professor Rancordas of University of Groningen, Professor Van Gisegem from Namur University, Mr. Chabert, President of Lyon Bar Association Incubator, and Mr. Odelmer, member of the Legal Service of the European Commission. My colleagues, Professor Monofoultier, Coordinator of Tech Law Clinics Consortium, Professor Moulin, Co-Coordinator, Mrs. Debord, Administrative Coordinator, Mr. Pons, in charge of European grants at UCLy and our Communication Department, deserve my warmest gratitude for the hard work behind today's event. I wish you the most fruitful exchanges and debates, and this is now my pleasure to give the floor to President Hermite, President of the Lyon Court Administrative Court of Appeal, who is a long-standing partner within this project. Mr. Hermite, the floor is yours.
Thank you, Mr. Doyen. Dear partners, dear participants, welcome to the dissemination event of the Tech Law Clinics. As President of the Court, I have the honor and pleasure to introduce a new session this year. The current health context could lead us to give up waiting for better days. This would have been very regrettable, and I am pleased that this beautiful project can continue. Which is made possible by the possibility of exchange by video conference. The technique is doing us a great service here. But any technical progress creates new citations and raises new questions. The law cannot ignore these questions. Technical Law Clinics is committed to studying such questions and finding legal innovative solutions. The work required of everyone is, first of all, to be open to these new technical possibilities. They must be considered acceptable, and the risks must be assessed. Then, it consists of being imaginative in the proposal, while remaining within an existing legal framework. Innovative solutions must be devised. Finally, it's necessary to be rigorous. The law is a tool that requires the construction of precise and solid reasoning. This is what makes its strength and enables it to play its role in the society. This webinar, today's, is an opportunity to present all the elements necessary to take part in this project. I hope that you will find it not only interesting, but also enjoy the legal thinking applied to a specific case, a beautiful specific case.
Have a good webinar and good work. Thank you.
Thank you, Mr. President. The Administrative Court of Appeal partnership is extremely valuable for our program. I'm delighted to welcome you all, regretting that it's only remotely. First of all, I'd like to thank the whole team who had to work hard late yesterday evening and early this morning for the organization of this dissemination event, especially the communication team, I3A agency, and the administrative coordinator. Everyone made fantastic work in such a difficult context. I'd like also to thank you, dear participants, for your availability and your flexibility to take part to this remote event. Lastly, thank you to our public for following us in a large numbers today. So let's start now with our first panel on the TLC method to take on future technological challenges. Please note that we will deal with the questions at the end of the panel, so do not hesitate to send us questions or comments using the chat function. So the first person to speak will be Marc Clément, President of Chamber at the Administrative Court of Lyon, and founding members of our pedagogical team, who will speak briefly about the historical aspects of our project. Marc, the floor is yours.
Thanks a lot, Arlette. I'm extremely happy to be here and to see that we have managed to do this event, regardless of the difficulties and the very tense situation we have today in Europe and elsewhere. I will just briefly explain why we came to this idea of mock trials in the context of new IT tools and new things emerging in technology. As Michel said, we had a conversation 4 years ago trying to find the needs and the ways to solve these issues related to new technology, artificial intelligence, and things like that. And we came to the conclusion that a very good way to deal with this issue would be to organize mock trials. Mock trials are not only things for us to train students and to have an impact in their curriculum and the way they learn law, but we think that mock trials are the best way to find solutions and to test the current legal framework against the new technologies. Why do we think that? It's just that when we talk about new technologies, most of the time we believe that this is new technology, so we need new concept, legal concept. For instance, people will talk about legal personality of robots or finding completely new legal concepts. But do we really need these concepts? This is not so obvious. And the best way to test that is to try to use the context of a mock trial to use a new situation, a situation that may happen in the future, like having an autonomous vehicle having an accident, for instance, testing that, and to see if the current legal context works fine or not. What is missing in the legal context? Maybe we do not need anything else than what we already have. And that's exactly the point. Testing a special case in the context of the legal framework that is today applicable to solutions may be a way to reveal that all the the existing legal concepts worked very fine even for new perspectives in IT, artificial intelligence, and things like that. Or it could prove that there is a need to develop some alternative solutions or more legal certainty through developing laws or things like that. This is not taken for granted for us that there is a need to modify anything in law, but possibly case law could work very fine in this context. So that's exactly the point of these mock trials from the point of view of legal research. And I think I will just conclude by saying that what we have developed is a way to do some kind of experiments in the context of law. This is absolutely not the traditional way to develop research in law. Most of the research in law is done through analyzing concepts and papers and case law, but this is paperwork. What we do here is, like in physics, like in hard sciences, it's to develop experiments in laws. And mock trials are exactly that. And I'm extremely happy to see that we have not only developed that in Lyon in the context of the teams we have in Lyon, but we have the possibility to do these experiments in different places in Europe with different teams, different views, and that's also a very important thing to consolidate the views and the research we are doing in this context. So thanks a lot for joining us today, and I think we will develop that through the day and the next steps in the mock trials. So thanks a lot.
Thank you, Mark, for these elements. And now I'm taking the floor to present briefly the main pedagogical objectives of the TLC program. TLC aims to develop a new educational approach using mock trials and the Spring School, bringing together 70 students in order, first, to make the students develop new skills in their academic background, thanks to the collaboration with practitioners and tech companies, thanks to the mock trial, of course, which enables them to embody the functions of lawyers, magistrates, and experts under real conditions. Which skill? Well, in particular, writing and speaking skills, but also collaborative skills by working in an international and multidisciplinary team. By this way, TLC aims to make their curriculum more focused on professional skills in order to optimize their preparation for the needs of their future and in order also to meet the needs of professionals. They will improve their employability, and this will also help them, I think, to plan their studies and their career objectives. And this leads us to the second objective of TLC, to prepare the student to their professional career by making them work on their orientation, by acting and by experiencing as practitioners during the mock trial. Third objective, to give the students a concrete understanding of the notions that they are studying, applying them in the framework still in progress of the challenging legal and technical implications of digital technologies. By using mock trials based on prospective cases, they will have to imagine solutions rather than copying ready-made answers into the manuals. So they will understand their added value as experts. Fourth objective, TLC aims to use this educational experience to generate research in which the students are associated. They can be volunteer to be involved in the writing of articles proposing innovative legal or and technological approaches to digital technologies based on the judgments from the mock trials and on the recommendations that will issue from the spring schools. Of course, this very short intervention doesn't exhaust all the objectives of our program, which will be presented very soon on our official website. So thank you for your attention. And now I'd like to introduce Piotr Tereskiewicz and Tom Venmans, members of our pedagogical teams, who will talk about the method of the project. Tom, the floor is yours.
So I will talk about the dissemination event about TC together with my colleague Piotr Tereskiewicz, and to understand the methodology, I want to issue some basic ideas that are connected to the challenges of the digitalization of law. So the first aspect is that the digitalization of law brings together two different professions and sciences. So the sound is very bad. Cannot hear me. Obviously, there's an echoing. There's an echo. Okay, to be honest, I have no idea how I can solve it. Maybe one step would be that I see that not all of you have muted their mics, so maybe when you are muting your mic, I should be have a better sound. Can you hear me? Is it better now? Okay, it's obviously yes. So I start again. Sorry for the inconvenience. So first of all, I'm Tom Venmans. I'm in charge of the organization of the Tech Law Clinic in Radboud University, together with my colleagues Andre Janssen and Pietro Ortolani. I just started when it was echoing about basic ideas that are connected to the challenges of the digitalization of law. And the first aspect is that, of course, law and computer science are two different professions. So law is a discipline of humanities, computer science, or mathematical discipline. And due to a professional typical way of thinking and methodology in both disciplines, the successful handling and the successful methodology is really linked to an interdisciplinary connection of lawyers and computer scientists. So, a suitable social and problem-oriented interdisciplinary exchange is therefore the decisive method and the recipe for the success of the tech law clinics. So, in many countries, legal education follows very traditional and conservative educational methods, and students come into contact with virtually no aspects of digitalization throughout their education. So the social and legal challenges of the digitalization play only a small role in the legal education. So there are almost no courses like legal tech, and therefore the method of the TLC brings together law students and computer science students to widen their view and their horizon in thinking and methodology. And the classical idea of technical clinics from the USA, UK, where the implementation of digital technology has reached an even higher amount of implementation into legal practice. So about the TLC, first of all, I will talk about the pages we set up, guide the students to find hearing to the mock trial. Methodological basis, the case. and the case is something taking place at the crossroads of private law and new technologies. So we'll just see the companies will coach you for the oral hearings, and the practical work of the facing students is a private law case that in this year questions of tokenization, blockchain technology, and smart contracts. In the second stage, are divided into teams, judge, plaintiffs, and defendants. Each team is composed of 4 law students and 1 computer science student on the case. So the lawyers have the computer students to understand the legal aspect of the case, and vice versa. Only by this way of cooperation, the case can be dealt within an appropriate and comprehensive. The final part of these steps is the mock trial itself. Other speakers have introduced the importance of it, and the students are preparing those things with several months. Within several months, they work on procedural documents. So the teams write like the so documents, and the team of judges at the end is like the judgment, the mock trial. The hearing takes place at one step, and the wit judgment can be seen as a pronounced and reflected work of several months. And that's in regard to the timeline, methodological ideas, you'll see method in Thank you. My colleague is, I think, following me in this.
Yes, ladies and gentlemen, good morning to everyone. I'm really pleased to be able to talk to you and follow upon what Tom has said about the project. So Tom has done the bulk of the work that was shared between us. He did not share with you a PowerPoint. Tom, perhaps you could activate your PowerPoint now so that everyone sees it. And I will add a few thoughts about what Tom outlined in general. So the idea is that in addition to having a group of around 10, 15 students, including both IT and law students, we have several external partners. First, an IT firm, then a practicing lawyer, and then an adjudicative body, usually a state court, like an administrative court in Lyon or court of appeal in Krakow or in Łódź, or an arbitral chamber in Piemonte. And the representatives of the parties are expected to advise us teachers on the course, join the mock trial, provide insights from their work, including new technology issues in the daily application of law. What is important and what I want to stress as an, I would say, academic result of the project, that we expect students to write essays as a part of the requirement that they should fulfill to complete the course. And we have a very positive result, at least for Krakow and Łódź in this respect, as there will be 2 essays written by students, published as articles in a peer review journal on first personalization based on consumer personal data processed by autonomous vehicles, and then generally on consumer protection in the context of our
So I think we lose the connection with Piotr. Probably we will have him online in few minutes. I hope this presentation will help you to take the measure of our TLC method, and you would like to experience it and to join our team. Why not in the next years? Perhaps we can go to the presentation of Bianca Gardella-Tedeschi. If she's okay. Bianca is also member of our pedagogical team, and she will present the results of the first year of our program. So Bianca, if it's okay for you, the floor is yours.
Okay, the results.
Bianca, can you hear me? Hello, Bianca.
Okay, because there is a strong echo. It's difficult for me to talk because I hear myself, which is not very nice. Anyway, the results are have been very enthusiastic. We had. I'm sorry, but I cannot talk like this.
Very well. We can hear you very well. There's no problem for us.
Go on. Okay. The problem is that
you can put your ear plug. It will be easier, I think.
No, it's not a matter of ear plug. Anyway.
We can hear you.
The results have been very enthusiastic. Students were very happy. We had a very high rate of positive answers to the questionnaire. I see that many people cannot hear. I think you only hear in the agence. No one else is. Okay, it's only on Skype. Okay, so very enthusiastic. The major point was knowing about tech law. Many saying that they learned things that are not taught at university. So this was very, very interesting from their answers. Unfortunately, first year was hit by the pandemic, so some of the program was lost. So we don't know all the answers about spring school and other things. But still, the answer from the students are enthusiastic. The collaboration between different departments was ranked very high. We had students from management and from the IT program working with the law students. And this was a major staple of the program. And then I would like to add outcomes also for Monica, something that Piotr already suggested, that there were papers published by the it's impossible to follow. Okay. Written by students, and in Università del Piemonte we had an edited volume with all the seminars that we proposed to students. So I think this is for it now. I'm here for questions or for more clarifications. I think if Monica can join us, she will add few from reaction also from the University of Uch. And I give the floor to the president of our section.
Thank you, Bianca. I'm sorry we can't have Piotr, I think, at least at the moment. Yes, that's okay for Piotr. So Piotr, the floor is yours for your presentation. I'm sorry, we have to wait just a few minutes. That's okay. So I propose to move on a short presentation by Marc Clément of the case of the last year, in order that you can understand the way the students are put in situation about the issues of new technologies. So Marc, the floor is yours.
Just to indicate maybe for the public that has not necessarily followed the mock trials that took place last year, the thing we had in common in all teams was a case where we had an automatic shuttle which was supposed to collect people on a request on their side. For instance, in Lyon, it was supposed to collect the different people by following a connection on a website. You request the shuttle to come and to transport you in a different place. But this shuttle had an automatic system and an artificial intelligence system which calculates the places where it should go depending on the number of requested trips. And if you had too many trips or too complicated trips, it avoided different areas of Lyon. And because of that, it was challenged that this shuttle has operated in a way which discriminates some areas in Lyon by not going to different places in Lyon. So it was a discrimination issue by an artificial intelligence tool, and that was the topic that was to be decided in the different places of the mock trials. So this is just a short presentation of the case, and we had different solutions, of course, in different places.
Thank you, Marc, for these clarifying interventions. I don't know if we can have Piotr online or not. Probably we will have to wait a few minutes to talk with him. Well, I propose to start with the first intervention. We are going to start with Pascal Pichonez, Vice President of the European Law Institute, partners of the program. Mr. Pichonez, welcome, and the floor is yours.
Thank you very much. Thank you very much also for this kind invitation. Well, in this brief address, I just thought first that when I was a law student in the late 80s in Fribourg, Switzerland, it was the beginning of legal databases in Switzerland, so-called Swisslex, that would not yet run on Windows, can you imagine? We were trained to use them and were amazed to be able to retrieve cases in a quite easy way. It was the beginning of a new area in which our task was no more to find cases, but to find ways to select and choose the information received. Technology has evolved, and so the technological understanding that is required from each lawyer and student to become effective users of those technologies. In my address, I want to underline that technology cannot replace legal mastery and understanding. Technology is very useful, and it should be understood and incorporated to some extent in the lawyer's life, but this should not be done at the expenses of a good understanding of legal issues and ability to assess one's own mind outcomes and legal reason. I think here I'm on the same line than Marc Clément. Let me therefore address briefly two issues. One, the rise of very specific technologies such as DLT, distributed ledger technology, and two, the use of algorithms in the decision-making process. The rise of new technology first. Our millennium is a time of incommensurable accumulation of data. Thanks to technological tools, it has been possible to value those data through data mining, data pooling, or data sharing. The new technologies have produced new commercial activities, possibilities to deal with data. The rate of data economy has been only possible because of the new technology. In parallel, the development of the DLT and the use of blockchain has enabled the secure the quality and immutability of data at a certain point in time. This certainty as some data at certain times is at the core of legal contracts, such as digital assets, smart contracts, or cryptocurrency. These two phenomena may even be coupled. One can easily imagine contracts over data that would be paid in cryptocurrencies or even be construed around smart contracts. There is a real need, therefore, to understand those technologies, their potential, but also their limits, which is far from easy. But more importantly, new technologies may trigger new legal issues. These new legal issues do not mean necessarily that there is a need to reinvent the wheel or to drop all our current principles and rules just because the underlying technology is different. The whole issue is there to find the right balance between adapting rules because of new challenges and sticking to well-developed principles that have proven their usefulness to lead to more justice and equitable results. Let me take some examples from the ongoing projects run by the European Law Institute, these areas to just exemplify my ideas. First, the UCLy principles for the data economy. Data generator, and these private persons, may transfer their data, knowingly or not, to data controller and data processors. These transfers or these rights to access those data are subject to contractual agreements. It is the same with those data controllers who, in their turn, might pool data or supply data to third parties and need also to set agreements on those data. And then data might also be processed or derived by data intermediaries, which again need contractual agreements to specify the rights of those parties. The European Law Institute, together with the American Law Institute, have embarked a couple of years ago on a path to fix some common basic principles for the data economy. All these contractual relationships have been addressed with a set of default rules, which are not compulsory, but give a starting point of discussion for the contractual parties and may be used by judges to decide on the rights and obligations of those parties. What appeared quite rapidly when drafting those principles was that effective principles could only work if one would understand the technological background of data pooling or data processing and at the same time would keep principles as close as possible to what already exists for analogous contracts. Let me take an example. Data pooling contracts may therefore be similar to partnership agreements or have issues linked to license agreements. But the difficulty, of course, is to determine if, and so to what extent, there is a need to adapt the fact that data may be a non-rebellious good. It is that use by one party does not exclude a simultaneous use by another party. This is often not the case in the material world of goods. Does it change the result, or is it a criteria which may justify new solutions? Of course, the answer may vary from one right to the other, and you have to test it. The work of the two main reporters of this project, Professor Christiana van der Horst, Vienna, and Professor Neil Cohen from New York University, Brooklyn University, in fact, has been tremendous in that respect. The results which are underway to be proved are fascinating. But at the same time, any reader may feel quite comfortable with them since they do not throw the baby out with the bathwater. You have principles that you recognize and that you can relate. Let me take another example. UCLy principles on digital assets, not smart contracts. The UCLy, the European Union, has two different projects, one on digital assets, what I would call revalorous assets, meaning when you use the asset, someone cannot use it at the same time. So the question is, what happens in case of bankruptcy with those assets? How to seize those assets to be sure that those assets will not be used somewhere else, because they might be just data. Material world and digital world may fall apart here, and therefore what should prevail over the other? You have an enterprise virtual data and at the same time maybe real goods, and you have a bankruptcy proceedings. How do you deal with that in order to be sure that whatever is available for creditors might still be here? And of course, private international law issues. Which law to apply with data that are in a world that is without boundaries, or almost without boundaries? Or how to decide private international law issues when the DLT feature that's used and where you have nodes in very different places. You can see there are a lot of typical questions of private international law that rise as well. And I'm not speaking about smart contract and blockchain, even though here, of course, we know in the stock market exchange world, for instance, we have already a lot of M2M contracts, machine-to-machine contracts, and therefore the question is, does it change something that it is on the blockchain, apart from the purely technological aspect? Or how to deal with fundamental rights that would affect those countries? Which fundamental rights, which country should have an impact on the smart contracts? Moreover, these issues are transnational, but contract is culturally embedded. It is also quite different if you have German law, French law, or English law that is applicable. The understanding of a contract as an exchange of promise, which enforceability is triggered by the existence of consideration, is submitted to different approach in interpretation. For instance, as a contract conceived, like in German law, as a meeting of the minds in which the efficient power of the will is central, including for fixing and interpreting ancillary duties rising out of the principle. This means that having an automated system to perform a pre-existing agreement, like a smart contract, may vary from the pre-understanding of such contract and its interpretation. Furthermore, the constitutionalization, if one say so, of contract law may have different impact according to the constitutional framework in a system. Of course, you may say there are unilateral principles on international commercial contracts that intend to harmonize those grounds, but this is soft law. And so the question is, what is the background understanding of those who run this smart contract and prepare? And because law is really law when it is applied by judges with their cultural and legal systems in mind, it might be of central aspect to see how this contract works in a very specific court system. Otherwise, they will not be smart at all. I mean, contract. Now, smart contract may raise controversies and tribunal issues. And there is obviously a need to have more automaticity in the decision process. So I could almost say that smart contract regime needs smart dispute resolution mechanism. And this leads me to the second point of my short address, the use of algorithm in the decision-making process. Because algorithms, as we know, are everywhere. More and more, they are also used to assess some probabilities of outcomes in lawyers' life, or even to take some decisions, for instance, in administrative matters, and potentially in other area of law. A good example is the Supreme Administrative Court case in Italy, case of the Consiglio di Stato. There was a decision-making process by a machine learning device, which was used to select and choose professors for the secondary level. A candidate who was not selected wanted to know on which grounds she had been rejected. The authorities had to tell her that they had used an algorithm for the first selection. For that reason, they would not be in a position to give her the reason why she was not selected. The Consiglio di Stato, the administrative court in Italy, had therefore to determine whether this process was compatible with fundamental rights, and especially the right to be heard. It declared the process void, since the right to be heard of that candidate was not respected, given that the right to be heard encompasses the right to get the main reasons for the decision. In this case, the reason for not being selected for the position. We all know that algorithms used to be considered as black boxes, since they mainly function on a system of correlations between features that are not necessarily relevant for a legal process. However, given the high number of cases on which the algorithm have been trained to identify an outcome, its accuracy in predicting the outcome on a new case might be high. But there might be two different things in assessing the outcome and deciding it. New generations of algorithms do no more necessarily imply a black box feature, as we know. It is more and more possible to retrieve some of the correlations that have been used by the algorithm to take the decision, but using a different algorithm. The whole question is, however, whether algorithms may be used as helping for the decision-making process, and if so, whether they can substitute in the end the decision maker. I'm not speaking about the quality of algorithm or about liability issue, though here I think a strict state liability would apply. My questions are rather twofold. First, what makes legal methodology so unique that algorithm may not fill in the gap? Well, to my understanding, methodology is all about explaining in a convincing way how choices have been made, why these choices are justified, and what are the implications. Therefore, it's all about implication, if I can say so. And each decision brings additional information to an issue or a provision. It is not about deductive processes, but about adding reasons for choices. There is no pre-established solution, never. Even in so-called easy cases, those cases are easy because we want them to be treated like that, because we want to stick, in a given case, to the separation of powers. Take an example, for instance, the duty to contract a liability insurance for dangerous dogs. Of course, the notion of danger is open-ended, and the answer, what is dangerous under such provision, or what is not, is a matter of choices, which should not be left to an algorithm, because it depends at the end of the day of the acceptance of such decision by the people. Where do you put the cursor? However, even if the word dog might be considered as simple, it might also be treated as an open-ended term. As a matter of law, in a teleological perspective, any dangerous pet might fall under the concept of dangerous dog. The only reason sometimes why the judge will not make such a step is linked to the idea of separation of powers. The judge says this is a matter to be decided by the parliament. But what would be a limit, in fact, for the judge to say, you know, an anaconda is a dangerous dog, and there's a compulsory insurance to be taken. Nothing but for separation of power. Finally, there's a further feature which is very important to me. It's the future decisions are taken into account for actual decisions. Algorithms are usually looking backwards to what has already been decided. This is, of course, an important feature in legal methodology, but often a judge will also consider future potential cases and try to test the decision that he is about to do and decide whether that principle or that decision would fit to these future potential decisions. So my question is whether an algorithm can do that and in a way that is then transposable, because the correlations that are made by these algorithms should be transposed then. So I'm looking forward, of course, to some of the presentations today to learn more about that. Now, if I would suppose that you use an algorithm for a decision-making process, my question is, can these results be really checked or balanced if we use decision-making algorithm on an everyday basis? Of course, the answer would be ask the judge. The judge will check the result. Now, how? Of course, he can check the result by looking at the outcome and say, would I get to the same outcome? If he says no, the question is, why no? Is it because I had envisaged other case law, or is it because the algorithm has done correlations that are wrong? So in a way to check the result, the judge will be forced to do the same process that all the time. And then the question is, of course, if I have to do the whole job of the algorithm, why do I use an algorithm? Okay, we could say you don't need to check the result of the algorithm. But that means you give the power to an algorithm. And you will maybe 2 or 3 algorithms.
Sorry, we are running out of time. May I ask you to wrap up, please, because we are very late yet.
I'm coming to the conclusion. So the question is, I can use 2 or 3 different algorithms to determine the result. Is that really what I want?
I'm not quite sure you
how can I then communicate the result to enhance the quality? So to conclude,
Pascal, may I ask you to wrap up, please, because we are really running out of time. I'm sorry.
Yeah, that's no problem. I'm doing that. I'm getting to the results. So I think that to use the full speed of smart contracts, for instance, we need to have maybe online decision-making processes. But then the risk that we get is an argument of authority, like was the case in the 5th century when the emperor wanted the judges not to decide by their own. They would count the number of decisions and opinions on each side. Now, if we get to algorithms doing the same process, we might end up checking the algorithm by looking how many are for one truth and how many for the other. This means a loss of control. And of course, the question is who has the forces to decide how this algorithm will decide and under which pre-understanding of law and culture. I thank you very much.
Thank you, Pascal. Thank you for highlighting these issues. I will give the floor to Piotr, but for a very, very short intervention, please, Piotr, the floor is yours.
Good morning again. It was a simple power cut that I had at home. So as we all see, we are deeply inferior to any technology that we use. So let me finish where I stopped. So I was talking about the success of having 2 student papers soon published as articles on matters of personalization and autonomous vehicles. So we see that as a part of the educational value of the project, to make students work interdisciplinarily and perhaps produce some academic work. There is still one thing that I would like to stress in particular, so the value of the spring school, which we had to give up last year due to a short-term cancellation due to pandemic. So we are looking forward to the first spring school taking place in March next year. And I want to stress that our students at our 5 law schools participating will have a unique opportunity of meeting one another. So there will be 5 groups of different universities mingled, working all together for a week with us, teachers and project coordinators, external partners from business, legal profession, and so on. There will be something like an educational fair, opening up opportunities after studies. So I think this is quite a unique opportunity for our students and at all universities involved. Thank you very much. And once again, I'm very sorry for the interruption.
No problem, Piotr. Thank you very much. So I will now defer to Mr. Francisco de Elizalde, who will propose to take technological efficiency as a new legal methodology. Thank you, Professor. The floor is yours. Can you hear me?
Yes, thank you very much.
Okay.
I'm trying to share my screen. Do you see my share screen?
On your side, you can hear me?
Yes, do you hear me?
You can speak.
Okay, thank you. So I want to thank the organizers of this wonderful event for the kind invitation to speak today, especially Professors Michel Canarza, Marjolaine Monod, and Madame Debord for the organization of this event. I also want to congratulate the universities that participate in this project, which is a fantastic initiative in these challenging times. What I want to present today is try to frame a new legal methodology for technology, okay? In the sense is whether the law or certain laws could be analyzed from the perspective of technological efficiency. And the first thing that I want to explain is precisely what do I mean by technological efficiency. Then I will provide an example. In the third place, very briefly, I will present the results connected to this of a survey that was conducted this summer to legal tech companies operating in litigation in some member states, including France. And lastly, I want to connect technological efficiency with the work that clinics conduct. And especially, and I hope it could be of use to this particular clinic. So the questions that I want to answer today, first of all, whether it is possible to analyze law in terms of technological efficiency, and second, if so, if there are legal rules that are technologically more efficient than others. So what do I mean by technological efficiency? So what I mean is whether I analyze the suitability or fitness of the law to interact autonomously with IT systems of different types, blockchain, artificial intelligence, etc., without human intervention. So a rule, a legal rule, would be technologically more efficient when it requires less human intervention, whether lawyers or other experts. The other way around, a rule would be less technologically efficient when it requires more intervention of lawyers and experts for it to work. And to a rule to be technologically efficient, it is characterized by two characteristics, by two key features. The first one is objectivity. Whether, for example, a breach can be determined without human intervention. For example, if a rule gives compensation for a delay in a flight, this can be assessed today without human intervention. Okay? The IT system can connect with flight data and determine whether a flight coming from Lyon to Madrid was late or not. In this sense, this rule has these characteristics of objectivity. The second characteristic is standardization, is whether the rule would apply equally to a variety of cases. A good example of this is a standard term that is deemed unfair. Okay, let's imagine a standard term of a certain bank that is deemed unfair by courts. All parties to the same standard terms will have their term declared unfair as well. Okay, so one legal decision will be affected a multiplicity of cases without individual analysis of case by case. This is also a characteristic of technological efficiency because it will allow, as I will explain now, the IT system to work autonomously without human intervention, at least in a second stage. So if we go think of objectivity and we think of its relationship with technology, let's connect it first with blockchain, for example. Blockchain works with a conditional logic. If this happens, then do that. For example, if the flight is delayed, pay 250 euros. It's one of the rules of the European flight compensation regulation. Once again, the breach, which of contract, which in this case consists of the flight being delayed, can be determined without human intervention just by simply connecting to flight data, and this will trigger and could trigger payment of compensation. This rule, in this sense, is highly technologically efficient. Instead, we have a term by means of which the parties must act according to good faith. This rule cannot work autonomously. It requires connection to what's called a human oracle. An expert, in this case a legal expert, that would has to determine whether the party is acting according to good faith or not. This rule would be less technologically efficient than the previous one because it requires human intervention. It cannot work autonomously. In terms of standardization, if we connect this to artificial intelligence, as you know, artificial intelligence works with data, especially big data, and the more standardized inputs to the algorithm, the more standardized output it gives. Meaning, the more common the law is, the more easy it would be to predict the decision of a certain court. That is why is that we think of its application with courts or in ADR, by having a rule that is highly standardized, the algorithm will reach more precise outcomes precisely because of standardization. This is how this characteristic is important for artificial intelligence. Allow me now to go to a concrete rule, a concrete example, which is the flight compensation regulation. Regulation 261 of this regulation is highly technologically efficient because it has the two characteristics. The first one, objectivity. This rule compensates for delay of flights, for cancellation, for denied boarding. I think we are already missing this regulation in this time, no? In which flights are so strict. For example, the case of delay, the regulation establishes compensation based on time and distance. For example, 2 hours delay, flight of less than 1,500 kilometers, 3 hours delay for new flights, 4-hour delays. Okay, so it's a combination of time and distance. This, once again, can be very easily determined by connecting the flight information with the flight data of the airport and seeing if the airplane is delayed or not, seeing its point of origin and the point of destination. This is currently done by legal tech companies. A second characteristic was standardization. The flight compensation regulation provides for what the Court of Justice of the European Union has mentioned as standardized compensation. So in the 3 examples that I showed you of delayed, well, the short distance flight, you receive a compensation of 250 euros, the medium ones 400, the long hauls 600 euros. And this is disregarding individual circumstances, which means that unlike normal compensation in which you have court go case by case, here every passenger that is delayed receives the same compensation. This is a highly standardized rule because the algorithm can work autonomously, and once the flight is delayed, can determine the plausibility of claims of every passenger that was on board, can even determine the exact compensation that is due. As you see, this flight compensation regulation is highly technologically efficient. It requires very little intervention of experts and hence is opt for automation. As I told you, the third part of this intervention was presenting and connecting the idea of technological efficiency with a survey that I conducted with a team, of course, in this summer to the legal tech companies that operate in litigation of all types of consumer claims. This was conducted in different member states, including France, and the outcome of classification of companies is the one that shows the graph. Okay, I won't go into details. Simply see that the blue part of the graph corresponds to legal tech companies that only claim compensation for air delays, air cancellations, and denied boarding, meaning compensation under the flight regulation, flight compensation regulation, which was the one that I presented. Almost 45% of companies do only that. And why do they do that? Well, they said that the reason for choosing this type of claims, and this was an answer that encompassed all intervening companies, is that the homogeneity of law is essential in up to 30%, or very important in more than 60%. So more than 95% of companies that are currently operating without intervention of lawyers in litigation, which is one of the key sectors because it involves legal reasoning. It was one of the most complex sectors to automate. They have been able to automate because of the homogeneity of law. And you see when the companies are classified, this is also information following from the survey, when the companies are classified by degree of automation, only those ones operating in airlines and in banking reach the highest level. which is the highest level. It's the highest level in which the IT system, which normally involves artificial intelligence, is able, and all types of machine learning, is able to determine first the plausibility of the claim, meaning if the claim would be successful in court, and second, they can establish compensation. This was done, and this is only achieved in airlines due to the flight compensation regulation that I explained, and also in banking, and this is mainly to the European Fair Terms Directive, and for the reason set of establishing fair terms. Once a court declares it will taint all contracts that contain it. Whereas in the low part of the pyramid, we'll see general platforms with a variety of claims which do require an individual analysis and a connection to human experts. This information was contrasted, was compared to the success rates in court. So it's not simply that they're saying this, that they're doing this, but also when litigation comes, they are being successful. Lastly, and with this I finished, how can this approach, if existent, if solid, how can it help legal clinics? And how can it possibly help a fantastic clinic as yours, in which you are experiencing and experimenting with technology? First one, as one of the previous speakers said, you not only have a theoretical approach to law, and a new theoretical approach to law that takes into consideration the impact of technology and its interaction with law. But also, you could do an empirical observation, for example, by relying on tools of predictive analytics connected to judicial decisions that already exist in the market. And second, it's very interesting because this approach could help you to compare legal rules from different countries and to see from a functional perspective, from the problem, which rule could be more efficient, more apt to work autonomously with technology. Once again, I thank you for your invitation, and I'm happy to answer any questions then that you may have.
Thank you, Francisco de Elizalde, for your intervention. I think we'll probably have comments on it at the end of the panel. And now I will give the floor to Professor Lucie Cluzel-Métayer. We'll turn it over you for 15 minutes on the subject of supervision of public algorithms. Welcome. The floor is yours. Can you hear me? We can't hear you, but you're on the screen. You can speak. We'll probably have comments on it at the end of the Is that okay for you? And now I will give the floor to Professor Lucie Cluzel-Métayer. We'll turn it over you for 15 minutes on the subject of supervision of public algorithms. We have a gap of time. Welcome.
Thank you very much. I'm not sure you can hear me.
Yes, that's okay. Can you hear me?
I can hear you, but with the live of Kirkley. Can you hear me?
Yes. We can hear you.
Can you hear me?
Yes, that's okay. Can you see me? Okay.
No.
Perhaps it's yes. It's better.
Can you hear me?
That's okay. Yes.
Okay. A part of my
Perhaps it will be easier.
Okay. Professor at University of Paris Nanterre and not anymore at University of Lorraine. Anyway, I want to thank the organizers for this invitation. In particular, my colleague Marjolaine Monod-Foultier and my friend Marc Clément. Thank you for giving us the opportunity to imagine with students what the law of the future will be like in such a practical way. Well, I hope you will understand my English, which is a bit rusty. My presentation deals with the jurisdictional control of automated administrative acts, in echo with the rich presentation of Pascal Pichonnas. The increasing mobilization of algorithm in public decision brings up legal questions, which are now submitted to the judge. The question is how to ensure that the use of algorithms by public decision makers complies with the law when they are considered to be black boxes. It is the very essence of the rule of law that the administration is supposed to respect law, and the administration must be able to prove that it does so before the judge if necessary. At this time, few cases have been taken to court, but they are very instructive. In the United States, the use of the famous COMPASS algorithm has been subject to judicial review. COMPASS is a predictive algorithm which aims to calculate the risk of recidivism of prisoners in order to decide whether or not to release them. The applicant, Mr. Loomis, a prisoner who had been kept in jail for high-risk recidivism, challenged the algorithm-based decision. He considered that his right to a fair trial, due process, to be convicted on the basis of accurate information had been violated. The detail of this case, decided by the Wisconsin Supreme Court in 2016, it's Loomis versus Wisconsin, are very interesting, as we'll see. French and Dutch cases are also interesting. In France, the case of the Parcoursup algorithm is particularly emblematic. It is undoubtedly one of the best-known algorithms in France. Every year, it processes the wishes of more than 850,000 candidates for higher education and has been the subject of an intense and high-profile litigation. In the Netherlands, two algorithms had been contested in court. In 2017, Arius algorithm, it's an algorithm used to deliver land use permits based on nitrogen deposition. And in 2020, Siri algorithm, which is a program to fight tax fraud, have been contested. These decisions deserve to be exposed to. They reveal major trends on two issues. The question of communication of the algorithm is the one that comes most often, as well as the question of its supervision. And I'm going to focus on supervision. Disputes related to the control of algorithms raise two sets of questions: the issue of explicability and the issue of competence. Let's look at these two questions successively. The first concerns their explicability. The obligation to give reasons for administrative decisions is now well established in most Western countries. The obligation to motivate implies that the author of the decision must fully and precisely set out the factual and legal reasons for which it is taken. This leads Dutch and French judges, faced with an algorithmic-based decision, to expect explanations from the administrative authority on how the algorithm works, since the understanding of the final decision depends on it. In France, the constitutional judge had thus prohibited the use of self-learning algorithms to make individual administrative decisions exclusively based on algorithm. It's a decision of the Constitutional Court of June 12, 2018. Because the judge is aware of the fact that the administration cannot explain how this algorithm works. Also, the French Constitutional Court authorized individual administrative decisions exclusively based on algorithms because he considers that the legislator provides sufficient safeguards. According to GDPR, it obliges data controller to master the algorithm and its evolutions and to be able to explain the algorithm. It's the same decision. However, making the algorithm explainable to citizens is a real challenge, essentially for two reasons. Firstly, because translating lines of code into human language is a complex task. And secondly, because it is difficult to identify the perimeter of the code's opening, integrating the elements necessary for a global understanding of the system while excluding modules that present security risk. Another limit must be underlined. The case of the United States Compass algorithm shows that sometimes the algorithm is developed by a private company so that it can't be communicated because of the industrial secrets. The petitioner, Mr. Loomis, considered that he could not properly defend himself against the decision to maintain his detention since he could not know the elements that motivated this decision. According to the petitioner, the right to due process was violated. The argument was serious, but the Wisconsin High Court considered that the algorithm only confirmed a decision made on the basis of other elements that could be known by Mr. Loomis. This judgment has been criticized because it amounts to admitting the use in court of an opaque algorithm whose operation is not understood by the judge. On the contrary, in the Netherlands, the judge is particularly demanding on this subject. The State Council decision of May 17, 2017 about IUS algorithm and the Hague District Court decision on February 5, 2020 about the Siri algorithm are very interesting. So in the first case, the Dutch judge sanctioned the administration's inability to explain the functioning of the algorithm. Thus, the administrative jurisdiction established a duty for agencies to actively and timely disclose the fundamental choices made when automated decision-making is applied. In the second case called NJCM versus the Netherlands, no administrative decision existed, so that the Siri case would lead to a private law court. In this case, the lack of transparency prevented the judge from controlling the algorithm. He considered that it is unable to assess the correctness of the position of the state or the precise nature of Siri because the state has not disclosed the risk model provided by Siri. The judge considered he could not control whether the invasion of privacy was not disproportionate to the objective of fighting fraud. The court did not think the fair balance of the second paragraph of Article 8 of the European Convention on Human Rights has been achieved. The court found a breach of the right of privacy enshrined in this article. The judge had concerning Siri that it cannot be excluded that the deployment of the algorithm in sensitive neighborhoods could lead to discrimination of citizens in these areas. Thus, in a way, he prohibits the administration from using this algorithm. This is what I wanted to say in this first part devoted to explicability of algorithm before the judge. Still on the issue of supervision, another question arises, that of the problem of competence of administrative authorities. Public authority is granted by law to take an act. It cannot, without a text, delegate its competence. In France, for example, executive bodies are given regulatory power by law or even by the Constitution. This means that it is forbidden to alienate the power thus conferred. The invested authority must keep control over the final decision. In this legal context, the use of the algorithm can thus only be an aid to help to the decision making. The public authority remains in control of the final decision. This is a problem in the case of discretion power. Discretion is deemed to exist when the administration has power to make choices between two or several courses of action, or where, even though the end is specified, a choice exists as how that end should be reached. Discretion allows to choose between two or more lawful alternatives. It differs from a bound competence. When the administration is entrusted with a discretionary competence, it must explain the way it will use it. It usually uses policy rules in directives. But what happens if these directives are replaced by algorithms? In Germany, Article 35 of the procedural law prohibits the use of algorithms in a situation of discretionary power. But in many states, as in France, it is not prohibited. However, the operation of the algorithm parameterized in advance according to predetermined general rules that will apply to particular situations to the strict extent that the two will have been predefined is contrary to the very idea of the discretionary power. Anyway, the French Constitutional Court considered that insofar as the provisions that provide for the use of the algorithm are limited to authorizing the administration to make an individual assessment of the situation of the citizen by means of an algorithm, according to the rules and criteria defined in advance by the data controller, they are neither the object nor the effect of authorizing the administration to adopt decisions without a legal basis, nor to apply rules other than those of the law in force. Therefore, the judge considered that the legal rules and criteria that the algorithm produced are defined in advance by the administration. They are based on legal basis, and there is no abandon of regulatory power. In a way, the U.S. judge say the same thing in the Loomis case. If the motion was dismissed in the first instance, it was because the judge considered that the compass algorithm was only used to confirm conclusions that the judge would have made in any case, as the influence of the algorithm was not decisive, and that they had kept control of the decision. This is to say that for the time being, the judge does not follow the doctrine which warns more and more about the risks of an apparent control of the algorithmic decision. The judge advances in measured steps, probably so as not to prevent the development of algorithmic administration, of which he is well aware, like all of us, of the potentialities. Thank you very much.
Thank you, Professor, for your intervention. Thank you for this comparative approach on this point, which is really of particular concern. And now I'd like to introduce Mr. Barbier, representing our partner Transpolis, which allowed our Chelsea students to experience the first autonomous road shuttle in Lyon last year. So, Mr. Barbier, the floor is yours.
Thank you very much. So thank you for inviting me and for considering Transpolis as a valuable partner for this initiative. And in my presentation, I will just explain who we are, what we do, how we help our customers improve road safety, and of course, why this initiative was so important and useful when it comes to all the issues that we have to face in the field of automated vehicles. So I can see the screen and my presentation, please. Okay, thank you. So just the big picture. So there are so many social challenges and trends influencing our urban mobility. So aging, pollution, road accident, nomadism, rarefaction of resources. Also, we all know that more than 50% of the world population will be concentrated in cities by 2050. So it will have a big impact on delays in transportation and also on global energy consumption and globally road traffic and everything related to safety. So growth in urban travel needs has been very fast, and the development of infrastructure has not been at the same level. And we consider that there are many things to do to improve road safety and create a more viable mobility systems, looking at everything related to economic, legal aspects, social, policy, and technology. That's the same thing. So in 2008, so more than 10 years ago, here in Lyon, pushed by the local ecosystem, so some people in the research, in the technology, in industry, and also at the administrative aspects and government level said we need something new to face these challenges in urban mobility and also have more safer roads and more safer vehicles. So in 2011, we created Transpolis with a mixed investment of 20 million euros coming from both the public and the private sector. And I mentioned and underlined the Groupama insurance company just because they're really interested in understanding what's going to happen in terms of legal aspects and also responsibility, who's responsible for what, and how they will price their new services. So Transpolis is something unique in Europe to test and validate automated vehicles, but also connected infrastructures, because we consider that there is a necessary dialogue between the vehicle and the infrastructure. So we have a scientific committee, and we work with a prospective approach of all these mobility issues, and also they work on more concrete things and applications related to the testing of automated vehicles and intelligent infrastructures. So what we have done to face these challenges, we have recreated what we call a fake city of 30 hectares of piece of land and a global 80 hectares of piece of land. And it is like a movie studio where we can recreate as much as possible the real-life conditions. So we have, you can see this bird view, so a ring, some boulevards, many streets with different intersections, different roundabouts, traffic lights, lightings, bus station. And the idea is, again, to recreate as much as possible the real-life conditions regarding the scenario that the vehicle has to face in the real life. So we can recreate some routes for public transportation, and as mentioned, Marjolaine, so this Navia automated shuttles. Here in Lyon, we have recreated the 1.5 kilometer route and tested the most critical situation that the shuttle has to face on the route. Some pictures just to illustrate what I mentioned. So streets, parking slots, roundabouts, fake walls, and connected traffic lights, and so on. And also to test the automated vehicles, we use robotized dummies just for safety issues, for sure. And then you can see the white car and the cyclist, so our robotized dummies. And so we can test for example, the emergency braking systems or the lane change systems. And if there is any failure in the system, then we go back to the customer and said, then you have to improve the technology and the embarked technology, LiDAR, radar, or cameras in the vehicle. So that said, there are so many issues and challenges when we speak about testing automated vehicles and having automated vehicles and fully automated vehicles in the streets. Technology issues, for sure, we need to have some robust technologies embarked in the vehicle. Social acceptance, driving behavior, the pricing, because the price of this technology is very expensive, and then everybody will not be able to buy cars with a lot of driving assistance system. And for sure, legal aspects. So this initiative has been very important for us, just because for us and for our customers and shareholders, because it helps us understand what is and what will be the legal framework in the future. And the most important thing for them is to understand who is responsible for what. Is it the car maker? Is it the supplier of the technology? Is it the city? So again, thank you very much for having us on board of this initiative. Thank you very much.
Thank you, Mr. Barbier. Thank you for this presentation, and thank you for your support. Now this is time for questions, even if we are late, as usual in this type of events. I have got a question for Lucie Cluzel-Métayer. I read the question. As you mentioned in your presentation, there is a possibility for justice to be given by algorithms. Who should be responsible for conceiving those algorithms in such a sensitive field, of course? Is there a risk if justice is outsourced and given by an algorithm that was previously conceived by a private company? Would it be legal in French law, for instance? You can't hear me?
Not the second part of the question, sorry. Can you?
You can't hear the second part or the first part?
The second.
The second. So the second is there a risk if justice is outsourced and given by an algorithm that was previously conceived by a private company? Would it be legal in French law, for instance?
Can you hear me?
Yes.
Okay. I don't think that it could be possible in France to outsource justice anyway. And I don't think that it is possible, such as in the United States, that a private company can develop an algorithm for justice, or it is possible, but it must be embarked in a contracts, public contracts, with strong assessment. I'm sorry, I've got an echo. It's impossible to respond clearly. Is it okay?
Yes, it is. That's okay for us.
I don't hear you anymore.
I can't hear you. Okay for us. Can you see me?
Sorry.
No. Okay. Sorry, Lucie. I will take another question. I think it will be easier. So I have also a question for Francisco. Many advantages of the blockchain were mentioned in your presentation. Would it be possible to talk about what happens with hacking risk, for instance? Would it be possible to incorporate a provision in the contract that is able to take the money back when it was allocated unfairly? Who should be responsible to determine that hacking indeed occurred in such a situation?
Many advantages of the blockchain were mentioned in your presentation. Would it be possible to talk about what happens with hacking risk, for instance? Would it be possible to incorporate a provision in the contract that is able to
in terms of,
money back?
I pointed out certain advantages of blockchain, but also certain limitations, which is not the panacea. So blockchain is a good technology, but quite limited technology for its interaction with law, as I said. In terms of hacking, well, the same thing could happen today. Think of a hacking a bank, for example. The same could happen today. So I don't think there is any added risk to this, and probably the same rules should follow.
Okay. Thank you, Francisco. Just a remark. This year, the TechLaw case will make the student works on blockchain and on justice given by algorithms. So you're just right in our theme. So we're running out of time. So I propose to take a short break with a short video describing Transpolis work before opening the next panel. So see you in a few minutes.
Well, good morning, everyone. Thank you for joining us at this dissemination event. It is my pleasure to take over the responsibility for chairing this event. So I'm Thibaut Moulin, I'm a lecturer here at the Catholic University of Lyon, and today I've got the pleasure to welcome Professor Rencordas, who will talk about the administrative vulnerability in the age of government automation. Then I will welcome Professor Jean-Marc van Gisegem, who will give a presentation about artificial intelligence and monitoring patients at distance. Alexis Chabert, who is a lawyer here in Lyon. And finally, Cornelius Oldmer from the EU Commission will give a presentation about platform responsibility for illegal content. So I'm honored to welcome these guests here, and I give the floor to Professor Rencordas.
Thank you very much. I'd like to share my screen, and I hope you can hear me. So thank you very much for the invitation to join you today. I'm very sorry that, of course, things didn't allow us to do this in person. And today I'm going to talk about an ongoing project, a project on administrative vulnerability in the age of government automation. So one of the first questions that I deal with in this project is basically how we can actually be connected to government. I believe there is an echo. Is there an echo? Because I hear myself very poorly, actually.
Do you have any earplugs, please? Because we can't hear you very well.
Yeah, I'm using my AirPods.
Ah, you already. Sorry.
So I'll try again. Let's see if this works well.
Yeah, you may go on, please. It's okay.
Okay, then I'll continue.
You can start your
presentation. So my presentation will be on administrative vulnerability in the age of government automation. And basically, my work right now is about what connects us to government, but also what detaches from us in the age of government automation. We all know, and our students are taught that citizens have to be able to apply for benefits when they are basically entitled to social welfare or housing benefits. This should be something that has to be done in an intuitive way. And this is mandated by the principle of administration. However, we see that nowadays not all transactions are intuitive, inclusive, or transparent, or even timely. And automation hasn't really helped us that far. So basically, there is a disconnect between government and citizens that coexists in the age of automation. And I think this calls for actually a presidential joke. So basically, one of the jokes that the President Reagan once told was basically the following: "What are the words in English?" And according to him, "I'm here from the government to help." And this joke, this joke, basically was meant to represent one of the things that we see very often in the citizenry, that government is not always perceived as being low threshold. It is something that actually comes with red tape, with bureaucracy. Basically, my research is about how government automation has added a new layer of complexity and bureaucracy to government and to interaction between government and citizens. We see this, for example, already in England, in the on automation of poverty, where the automation of many systems on universal credit system haven't really helped citizens to have more access to services, but it has made it even worse, has made it more punishing for algorithms. And in this sense, I distinguish myself a bit from research on automation of government, because most people talk mostly about how algorithms work, and I'm not that interested in how they work, but more actually on how citizens can interact with government itself. And actually, more specifically, how they actually interact in the sense that government may not be taking into account the vulnerability that they may have at some point. So when I talk about administrative vulnerability, I think it's important to talk about what it is, what excludes people from government automation, and possibly how to fix it. So government automation very often doesn't take into account the fact that we are
we can't hear you anymore. I'm sorry to interrupt you, but maybe you have a problem with your microphone, or... Can you try talking just to check if we can hear you, please? Yeah, no. Non, elle parle, mais il n'y a plus rien. Ah.
Is it not working?
Yeah, that's better.
Yeah, it's better. Okay,
yeah, that's fine. It seems it works. So yeah. Okay. I think you can carry on.
I think it's better if I just not share the screen, because that probably works better as well for me.
It does work. That's fine. You can talk now. I think it's all right. Sorry.
Okay. So I don't know exactly when I was when you stopped hearing me. Basically, I was explaining that the process that drives my research right now is the one on administrative vulnerability, and this process means that at one point in our life, we'll all have full or partial inability to exercise our rights before public authorities, and because we cannot fill in some papers, because we cannot engage with digital technology, because we simply do not have the ability to actually exercise our rights. This complexity that exists has to do also with the fact that government automation is being designed for the average citizen, while there are times in our life where we are not the average citizen, where we might be too vulnerable to be an average citizen because someone has died, or we feel vulnerable because we are in a situation of fragility, but also because there are a group of people that will never be the average citizen. And actually, also this is very treated in a way that they have the right to participate in public life on equal terms. So my idea of administrative vulnerability is to address a gap in the literature in public law, which actually always sees the citizen as an average citizen. In consumer law, we do have the concept of vulnerable consumer, who is basically the citizen who cannot always exercise his rights or her rights. And my idea is basically to actually import the concept of vulnerability from consumer law and adapt it, and actually see how we can actually explore it in the context of public law, where we basically are guided by an idea of equal treatment that is very much taken account by average citizens, and we only do an equal treatment when someone has a disability or someone is marginalized. But administrative vulnerability doesn't always speak about being marginalized. Very often it's because we basically equalize too much citizens, and it's important to actually depth into the reasons why people are feeling, why they are feeling vulnerable. So basically, one of the things that I look into in my research is to look at what is causing digital divide right now. So with the lockdown, we have a lot of citizens throughout the world simply do not have the same access to homeschooling as others. For example, children had a good internet at home, follow online classes, but many children don't even have a computer at home. So they were not able to follow classes in the same way. They lagged behind. The same applies to to many services. So in England, there were many reports of citizens who were not able to have access to their, like health systems or welfare systems because they didn't have a way to connect to the internet or didn't know how to use it. And the thing is, we are not really like looking always into the root of the problem, the root cause of the problem, and also the complexity thereof. So we talk about government automation, and it is really important to talk about how how algorithms are formed, but it's also important to take a step back and see, well, what happens when people don't even, can't even like switch on a computer and really understand what's going on. And the thing is, there is quite a lot of literature that has been talking about this, about the problem of inclusive access. But I think it's important that we actually, as lawyers, also think about the digital skills that are required, the new form of digital citizenship that is emerging, and how we actually can ensure that all citizens can participate equally in government. So that's also this inclusive access means that citizens will trust government more, and they will be able to actually uptake technology. And all this, this cycle of, of reasoning can actually help ultimately that to contribute to actually a better system with greater trust in governments. And I think it's important because once citizens feel that they are vulnerable before government, that they cannot exercise their rights because things are too complex, then there is like a barrier that is erected between government and citizens. And that is something that I address particularly in my research, because I think it's important that we actually look at it from an interdisciplinary perspective. So just to actually move to the last part of my presentation, I think it's important to stress that digital exclusion has very broad legal implications that we haven't been really talking about, because the digital divide in law has been discussed from the perspective of, do we have a connection, like an internet connection, access to infrastructure or not? And I think digital exclusion is a much bigger and broader problem, but it has to do with social capital, with digital literacy, with the fact that not everyone has motivation to uptake technology as well. And all of that has an immense, impact on the way in which we exercise our rights, the way in which we actually interact with governments. There are some solutions that we can actually propose to say, well, let's fix it in some way. For example, I know that in France, there is, of course, a so-called le droit à l'erreur, the right to make a mistake, that tries to actually, at least in theory, to give a solution to people when they make a mistake. But it is a very limited solution, as far as I understand, as an outsider. A very limited solution that cannot always be applied to everything. So in that sense, I think it's good to have something that promotes administrative leniency, and many countries have this perspective. But it's also important to actually think, well, from a legal perspective, this should be done not only in tax law or when someone makes one mistake in their lifetime, but we should actually have some kind of mechanism that allows us as administrative lawyers or public lawyers in general to actually see, well, if there is a vulnerability, if someone is facing going for a divorce, the loss of a loved one, perhaps there is more that government can do to actually address that makes it easier. So, for example, in Estonia, the idea of the digital government is an idea of digital government that is all path dependent, that is actually very much based on automation in full sense, which actually means that citizens do not need to do as much as our citizens have to. And I think it is important that when we think about digital government and when we think about the need to solve administrative vulnerability, that we also do it from the perspective of also transforming government and the way we interact with technology. So digital government should not be seen as basically an online version of a paper-based government, filling in the forms the same way we would do it by hand, but basically should be regarded in a transformational way where we actually work from a better and cleaner slate, and also try to think about what are the solutions that we can import from other countries, like Estonia, or some of the Scandinavian countries as well, and see how we actually can produce not only digital assistance and I can create systems of leniency, but also design digital government in a transformational way, where basically automation is used not only to produce to deliver algorithms that will automate decision making and save costs, but also to make sure that citizens do not have to go through the same bureaucratic procedures that we very often see that is happening. So I have no idea what I am over time, but I think that was basically the core of what I wanted to share with you. Thank you, and my apologies for the sound problems at the very beginning.
It was a very interesting presentation, so I think we should carry on. And here, Professor Jean-Marc Van Gisegem, who will talk about artificial intelligence and monitoring patients at distance, very topical. So you have the floor, Professor. You can start your presentation, Professor. Can you hear me? Oh, seems to be. Seems he can't hear us.
Thank you very much. Thank you for the invitation. Do you hear me? Is it okay?
Yes, that works. Thank you very much.
Do you hear me? Okay, we have a problem of sound. Yes, and do you hear me? I don't know. I have a problem.
It's all right. We
Wait
can't,
a minute.
we can hear you. We do hear you. It's fine. It works.
I hear you, but I can. Okay.
No, everything is all right on our side.
Perfect.
So.
Thank you very much. Okay. Thank you very much for the invitation. Yes, it's okay. Thank you very much for the invitation and for making this event or webinar possible with this situation. Do you have my my PowerPoint presentation? Because I don't see it. Okay. Because I Okay, then I will speak about artificial intelligence and monitoring person at distance. And of course, it's really an ongoing topic, at least in Belgium, and I'm sure also in France and all Europe. And by doing this monitoring at distance, we obviously use algorithms in the way to monitor such patients. We do the scope of the talk today will be artificial intelligence and monitoring patients, and more specifically on a view from a GDPR perspective. Then it will be mainly data protection to see how it can work and what are the problems we can face in such a system. And we have a definition of the OECD, and I won't read it. It's on the screen, and I will go immediately to the view of the technologies, which are not only techniques as we always speak about. It's a legal point of view, it's a legal perspective, it's a legal issues, social issue, but also, and that's the most important point from a GDPR perspective, it's a multidisciplinary interaction between computer scientists, lawyers, and sociologists. If we want to have a privacy by design engine, we need to have a discussion between the different professionals we have around the question of the technology we want to develop. Of course, technology are more and more in the professional world, are more and more in the decision, even in the health sectors, as we have seen some engine or some products developed to help physicians to take decision, and even some AI engine took the decision at the place of the professional. And we have also a legal environment of the AI, and we had excellent speech this morning. What we see also, it's algorithm needs food, needs data, and it's very hungry, and is also needs food coming from everywhere, coming from big data, coming from data center who share or voluntarily or not the data. What we see in Belgium and all around Europe, it's a switch from intramuros to extramuros healthcare. Then we are switching from the hospital to the house health. We have also a multidisciplinary interaction between physician and non-physician regarding their respective access to health data. We see that we speak about the patient between psychologue, physician, social environment also. And now we have new actors, which are the developers, the Apple stores or the application stores, and so on. Then we have new actors coming in this multidisciplinary interaction about the patient. About data protection, what we have to see, it's a question of minimization. We see that we have a privacy cascade, privacy streaming going from anonymous data to non-personalized data. That means that if we want to have a GDPR compliance system, we have to play with the 3 layers between anonymous data and non-anonymous data. Then if we need only anonymous data, it's enough. We don't have to deal with other kind of data, and so on. We have a first issue about the consent and information. In most cases, in mobile health environments, we need the consent, even if it's not the good licity or legal grounds. We often ask consent from the patients, and it requests maybe specific information. Let's think about information about the algorithm itself. We use algorithm to offer health services. How can we explain, or how can we have informed consent with a kind of blind algorithm we use in the engine? We have a potential clash with the IP rights between curator of the algorithms, designer, producer, and developer, which is very, very touchy when we ask consent, which has to be informed. We have also other issues linked to the information or to the consent, and even from other data subject rights. It's first the right to delete, the right to erase the data. It's quite difficult to identify the user behind the mHealth service. We have also a question of right of portability. It's very hard to separate data that are genuinely generated by AI and the ones that are actively provided by data subjects. It's very hard to tell user, okay, you can get back such data, but not those ones, because they are very, very linked they are linked together. It's very, very hard to say, okay, this kind of data, it's good for portability. This one, it's not. It's the property, if we can speak about property, which is not the right word in GDPR, of the producer or the physician. We have also a high cost generated for being GDPR compliant. Doing a system which is GDPR compliant can be costly and can be an issue for the producer of such an engine. We have also, as we talked about that a few minutes ago, a potential clash between data protection and intellectual properties. We have a potential tension between innovation and data protection as the companies are reluctant to open scheme. They are reluctant to open source the algorithm. And we have a problem of secrets around the algorithm, and it's coming from a notion of competition. We have competition between producer, between a creator of algorithms, and they don't want to deliver the secrets behind their own algorithms. That's raised a question of transparency, of openness of the algorithms, as we cannot deliver a full transparency on the algorithms. We had this problem on this COVID-19 in Belgium, facing the question of transparency, because creating the Corona Alert, which is an application making possible to trace the people who have been infected by COVID, and the question, the issue was about the openness of the application doing such a tracing. It might also impact the right of portability. We have also a question of cloud computing, and you have this kind of issue in France with health data, which are hosted by Microsoft, and we have an impact of Schrems 1 and 2 decision on this issue. The whole problem is, are we speaking about companies who have the establishments in USA, or issues about the localization of the servers? And that we are discussing this point in Belgium, as we are doing papers, we are doing discussion about how do we have to interpret Schrems 1 and 2. Are we doing a trans-border flow when transferring data within European servers owned by Microsoft, even if it's a US company, or it's still conforms to GDPR, and we are doing such a transborder flow because all of the servers are located in Europe. And that's a big discussion. It's also a war between some cloud computer provider. We have, I will go very fast about medical device, as I think I am out of time. I will go immediately to liability. We have few actors. The first one is the producer. He will have to be compliant with the regulation of medical device, with liability for defective products. General product safety applicable is applicable to AI, and we have also the GDPR. The producers can find its liability engaged through this multiple legislation. And we have one European one, which is the GDPR. We have a homogeneous regulation. We have also homogeneous regulation through the regulation on medical device, a liability for defective products, even if we have to change this directive. Indeed, this directive is not focused on complex system which hosts algorithm. We need to modify the definition of products to include complex engine, complex system. And about the GDPR, of course, we should ask from the producer a privacy by design or by default. And we need also to make a distinction between data controller and data processor, which is not really easy, because we see that the AI engine can be produced by someone, used by someone else, and also fed by a third person, which is the patient. Then it's difficult to see with exactly the data controller or the data processor. And also we have the national laws acting in sector of liability, which work quite well so far, but from a European homogeneity, it can be an issue. It can be also a kind of liability shopping between the states, and the producer might choose a country where the national law is less strict on liability than others. We have also a question of liability on the principle of minimization, because I told you AI needs food, needs data, and how can we manage the needs of data with the principle of minimization? Then we should also facilitate the data management, and that's part also from a producer point of view, they need to facilitate the data management information. We have also a liability at the level of the physician hospitals, because they are responsible for the confidentiality and security of the processing. They have a choice, they have to choose a good data processor, a data processor who offers safeguards on the security, or offer a security which is compliant with the state of state of the art, and also responsible for a good choice of communication technology with a server who hosts the data, for example, secure messaging and so on. We have also issues in regards with the message received. Now we see that the physician receives a huge amount of message. They have a problems of data management. They cannot manage all the messages. Then there's a loss of critical information. And that's a huge point. It can be constrained from the physician by choosing the AI system, as they are afraid about the loss of critical information due to the huge amount of message. And they ask for a legislation, or at least from decision acting or surrounding their liability. They have also a problem of an inaccuracy of the information delivered by the program or from the algorithm, and the risk of wrong decision. And that's coming back to the choice of the data processor or the producer of products. And that's a very, very important issue, what we see coming back in each conference we do or each consultation we make in this sector. And also we have a problem of liability for the patients, which have a problem in using the device. Then they might send incorrect information, driving or leading to a wrong decision from the physician. And who is responsible at the end? The patient or the physician who gives wrong information on the use of the device? Or even it might be a liability from the producer, because maybe the user explanation it's not clear enough. Then we see that on the same problem, we have an interaction of liability, which is not very easy to divide between actors acting in this processing. And I think I made a very quick overview on what we see on the access to health data and on the monitoring patient at distance.
Well, thank you very much, Professor Van Gisegem, for this very interesting presentation. I'm sure we will have questions. And now I've got the pleasure to pass over to Alexis Chabert, who came here in person, so thank you very much. And you have the floor.
Thank you very much. I'm very pleased to be with you today, and according to the circumstances, to be online with you, and to present the Bar Association, since I am a member of the General Council of the Bar Association of Lyon since January 2017. And my goal and the goal of my presentation is to show you what the Bar is doing to implement innovation within law firm. And I am in charge for the Bar Association of Innovations with Valentin Olierou, who is another lawyer of the Lyon Bar. And the chairman of the bar asked us to put innovation in front of our objective. And we create what we call a committee, an Innovation and Exercice du Droit, which is a law practice committee, with the goal to lead the French bar incubator. And we create in 2017 a bar incubators. And the goal of this incubator is to launch some legal tech projects, led by some lawyers of the bar. But first of all, I want to present you the history of this creation and the creation of this specific committee of the Lyon Bar Association. At the beginning, I was in charge of what we called the protection of the perimeter of the law. You have to know, to make it very simple, that in France there is a law which protects the perimeter of the law and to make it only practiced by some regulated professional. And this law is saying that when you want to advise, to give legal advice and to draft some legal documents, you have to be part of this regulated profession. So my first task was to be the president of the committee, which was in charge to defend this perimeter. And we were facing a lot of commercial company, and I know you have a lot of examples on the web, and those companies were doing our job. And our first reaction was to say, okay, it's forbidden for you to practice law, because in France there is a very specific law saying that law is not a product like other products, and law has to be practiced with some ethic and with some quality. And only professional and only regulated professional can do this job. And my goal was to implement trials against those companies. But from time to time, and with the evolution of the legal tech on the web particularly, we decided to change our approach. And in 2017, we decided to mix two different committees. The committee which goal was to protect this perimeter, and the innovation committee, because we thought at this time that it was time to urge our lawyers of the Bar Association to innovate within their practice. I mean, it's not enough to protect the perimeter, because the perimeter of the law is not here to protect lawyers, it's to protect citizens. I mean, the ethic code of the Bar Association is something to protect citizens and to clients of the law firm, and not our law firm. But we know that it's very important to put ahead this ethic code. But we have to move forward with some new way of practice. And this is the reason why we decided to create this new committee. And with this new committee, we create the incubators. And it was the best way for us to say, okay, legal tech do not have to be opposed to lawyers, but lawyers should be the first creator of legal tech. That means that from this time, from 2017, we started to create legal tech with lawyers. And on the markets, on the law market, because the law is a market right now, we have to be aware of that. I mean, we sold law documents like we sold other kind of documents. So we have to enter these markets as a lawyer with new practice, but we are with our ethic. And it's a crucial point for lawyer in Lyon and for lawyer in France, is to keep our DNA, the ethic, but to use some new tools to be able to answer the needs of the citizens and of our clients. And what we have done so far is to convince the lawyer of the Bar Association to create their own legal tech. And now we have 11 legal tech, which are led by lawyers. That means that those lawyers create a different company aside of their law firm to be able to develop some new product or some new way to sell law to their clients. And those 11 legal tech are a real showcase for the Bar Association and a real showcase for innovation from the Bar Association. Our goal is really to convince people that innovation is inside the profession of lawyer and of attorney. And we have a lot of different examples of different legal tech, and I can say today that there is no field of law where there is no innovation. That means that innovation is everywhere and in every field of law. And I can say that 5 years ago, we talked about legal tech destroying lawyers, and right now we are talking about legal tech creating by lawyers, and it's a great victory because we are inside the market. We are not outside the market. And it was a kind of introduction because to be very close to the subject of these tech events and tech law events, I wanted to talk about automation and talk about prediction. And these two fields of law, we have some example in the incubators of some kind of legal tech created by lawyers, which goal is to make innovation within their practice. And regarding those two examples, we have many other examples, but I had to choose. I want to talk about Agrum and Legal Pilots. You can see on our website those two companies. We create a new way to practice the lawyer practice. And those companies decided to say, okay, one of our job is to create legal documents. But you can find legal documents on the web. I mean, there is many companies who create templates and we create contracts. And beside lawyers create contracts and templates for a lot of money. And the goal of those two companies, which are led by lawyers, is say, okay, we will do the same. We will create templates and we will create a website where a client can go and answer some question, and after answering some question, he will receive a contract, very simple contract. The goal is not to create a very specific contract, but to say to the client of a law firm, if you want a simple contract, you can go on our website, you can use our tool, and you will create your own contracts. And legal pilots say, okay, it's automation, and you're going to create your own contract by your own. But if you have some specific question, every time you can ask a lawyer to come beside you to help you to answer a question or to adapt the templates to your specific situation. And that means that these two law firms decided to say, okay, it's not a big deal to not create contract from the beginning. My job is to adapt contracts. And it's a good way to say, okay, the lawyer is still inside the markets, but is developing a new activity, not an activity to draft contracts, but to adapt contracts, which is a kind of different. Agrum, it's another kind of company. It's work on social law, and it creates all the contract regarding social relationship between an employee and an employer. That means that from this website, you can create a contract, you can create any kind of letter that you have to use when you're an employer or you're an employee. That means that, again, it's automation. But this automation led by a law firm make us possible to stay aside our clients, to not let those clients go on the websites, on the web, and to see contract and to see other company who deal with some very low cost, some kind of low cost templates. So that means that with this new product, we can keep in touch with our clients. The other subject I want to discuss with you today, it's a subject for me very interesting because I'm a lawyer. I would say I'm a real lawyer. I plead. So that means that my principal job is to try to anticipate the decision of the judge. And it's very difficult, of course, and most of the time our client is asking us, but could you ensure us that we're going to win the case? If you can ensure us that we're going to win the case, I don't want to go on courts. So it's really difficult to assess the level of certainty to win or lose a case. That means that 5 or 6 years ago, several companies developed some new algorithm to be able to predict, to make some prediction regarding the result of a trial. It's a very difficult activity for two reasons. The first main reason is to create this algorithm, you need some data. And those data, this is the judgments of the courts, of the tribunal, of the French court and French tribunal. And you have to know that in France, at least, those judgments were not accessible to everybody. You have some high court decision, you have some court of appeal decision, but the decision was from the Tribunal of Commerce, for example. You were not able to access those decisions. But if you want to create an algorithm, and if you want this algorithm capable to assess the risk and the predictive result of the trial, you have to give him the judgment from all the different kind of tribunal. And in 2016, the law decided to say, okay, we have to implement tools to be able to give to those companies all the decision rendered by those jurisdictions. And so far, we have a lot of discussion regarding the way we will put decision on the web. But so far, it has been impossible for the French government to be able to launch this accessibility, this full accessibility. So that means that those companies which are working on prediction right now have a data which is not a big data. So we have to be very wise when we use those different tools to to assess the risk and to assess the certainty of the issue of a trial, whatsoever trial. The second problem with predictive justice is the way these algorithms are created. And it's a main issue for lawyers, because at the very end, when those tools will use a big data with a lot of decision, and when the statistic given by those algorithms will be based on big data, we will have to ask ourselves if the results is fine, is really I would say, really close to the reality of the decision of the judge. That means that we have to know how those algorithms are working. And it's a big issue. I heard one of the professors talking about IP, and it's an issue because those companies doesn't want to show us the way how they create this algorithm, because it's protection for them. And for us, it's a limit of the utility of those algorithms. That means that we will have to be very wise with those different companies. And my position is that if we have different companies with different results, we will be able to compare those results, and it's going to be going to give us some kind of certainty regarding the efficiency of those tools. That means that for now, we have to be very wise because we do not have data. We do not have big data. Tomorrow, when we will have big data, we will have to be wise because those different algorithms will work differently, and we will compare the results. And that means that when I said a few minutes ago that those tools, those legal tech will not destroy lawyer, we will still have a main job to fight against those statistics and to explain why this result is better than these other results. So this could be my conclusion. I would say that those legal tech are tools. Those tools are only new way for lawyers to practice their own job, and it's not a way to replace the lawyer within its practice. And when you know more precisely the result of a trial, you will be able to give more advice to your clients. But never those tools will replace the lawyer. This is my conclusion, and I'm very optimistic regarding that. I do think that our client and the citizen will still have some need regarding the law profession and whatsoever, lawyer, bailiff, notary. I mean, the law is more and more complicated, and the way it's explaining on the web give us more and more capability to advise our client. The full data that you find on the web is not very legible, is not very efficient for a simple citizen. So our task, our job, is to use this innovation, to use these new tools to be better lawyer, but not to replace lawyer.
Well, thank you, Mr. Chabert. It's amazing to hear what happens in Lyon here. So many technologies and so much innovation, so thank you very much. And now you have the pleasure to give the floor to Corneliu Odelmer, who is going to talk about the platform responsibility for illegal content. So Mr. Odelmer, you have the floor.
Thank you very much. Also for the opportunity to participate in this event. I hear myself very strongly as an echo, but I guess it's not possible to avoid that. So we are right now at a turning point in the EU approach to the question of liability. There is a discussion about coming up with a digital services act at European level, which would reform the current liability regime I am a lawyer in the legal service of the European Commission, so we are dealing with the existing law and defending cases in concrete cases regarding liability. So I will try to give you at this moment in time a glimpse of what is currently law in the European Union and its member states. And I will. My presentation doesn't start. Oh, yeah. By outlining the overall field of problems that we encounter when it comes to platform liability. And we are often in this context, or always, faced with a triangle situation. On the one side, so we have three parties which have rights and obligations vis-à-vis each other. And the legal problems need to be sorted in each relationship individually. We have the platform to start with, which can be companies like Amazon, Google, or Android, but also devices like iPhone, and also potentially other services like in the future, like self-driving cars, which operate as a platform for applications of maps and driving applications, self-driving applications, etc. Then we have the online content services or goods provider that uses this platform to reach its clients. And then we have a variety of third parties that access the services, goods, via the platform. That could be the content users themselves that have direct access to the services, or customers for goods and services, or even the data users, like advertisement companies, which get the information, the data from the platform in order to place their products better on the market. We can also have, however, public enforcement authorities trying to enforce certain rules which apply to goods and content on the platforms or the content providers. Now, fundamental issues arise with a triangular situation. Firstly, as we have seen the triangle that I had in the previous slide, there are two potential debts to third parties when goods, services, and content are distributed via platforms. It's on the one side the content, goods, services provider himself, but also as a second debtor, the platform. Now, union law has addressed this issue mainly by limiting the rights to the liability of in this situation to the direct provider of the content or goods, and by creating a safe harbor for the platforms. The concept in the year 2000, when that safe harbor was introduced in the e-commerce directive, was to promote the development of this then still new technology, and to limit its exposure to liability in order to make it thrive and grow. At the time, this was a niche market. Platforms didn't exist to a large extent. And therefore, a complete safe harbor from liability seemed feasible at the time. In the year 2000, the e-commerce directive was enacted. new technology. And can you hear me? Exposure liability in order to be. Because I can hear myself. But at the time that this was our niche, our platform didn't exist to a large extent. Let's just continue. The second problem outlined in this triangle is that platforms function like a gateway when it for services provider to provide their content and providers to get their to the customers. So issues of fairness in competition between providers and the providers vis-a-vis the platform arise. And this has been addressed by the European Union's competition law framework. So safe harbor for the question of the the problem of two debtors, and competition rules regarding the gateway issue. I will. Can you hear me? I will now start with the issue of liability. And the safe harbor. So the question which arises, and We've heard of it in several presentations now, is the question of how much the existing rules on liability, which applies to the physical world, apply also to the digital world without being adapted or changed. Now, as I was saying, we had a safe harbor rule, so a modification of the rules in the year 2000 with the e-commerce directive. But that rule proved to be too broad, and we can see a gradual application of the existing physical world liability rules over these 20 years since the safe harbor rule was instated. But however, with a certain development of new concepts that delimit the safe harbor rule from the application of the rules, the liability rules for the physical world. There are a number of key cases that I would like to make reference to today, very quickly, which created these new rules. New principles for liability. The Uber Airbnb case introduced the concept of market creation and intensity of control. Market creation means the question of whether the new service, the new platform, created a new market that didn't exist before, in which case it would be liable, or just is intermediating an existing market in a better way, in which case there is a lesser argument for liability. The intensity of control, the question of control, is to what extent does the platform control the services and goods or content that is offered to the final customer. The more control, the more there is a reason to argue that the platform should be liable in parallel or mainly, rather than making the services and goods provider liable. In the L'Oréal case, the question of active-passive was introduced. I mean, how active is the platform in the distribution of the content? L'Oreal was a question of, was about distribution of products via eBay. So how active is eBay in distributing these products? And the more active it is, the more liable it should be. Glavishnik is a very recent case on hate speech. The question is, how much should the platform control the hate speech that is passing through its intermediation? And how much does it have to pay attention or to monitor similar speech? I mean, does it have to be notified of a specific statement that constitutes hate speech, or is it enough if a notification is very general and then it has to verify all similar content and thereby monitor to a certain specific way the throughput through its intermediation, which could create obviously a huger effort on the side of the platform. And finally, GS Media, the GS Media case, adapted the liability rules of the copyright regime, which are delimited by the concept of communication to the public, enlarged this concept to the activity of platforms and thereby made them more liable for illegal distribution of copyrighted content without the consent of the copyright owner. So we can see that there is a gradual application of the existing physical world rules by means of certain new concepts to the intermediation services of platforms. Now, with regard to the gateway aspects that I was mentioning before, so the question of how it can be ensured that there is fair competition of all parties which are passing through the platforms to reach their final customers. The union law has so far mainly applied competition law to the cases. The concept behind competition law in this context is the special obligation of dominant players to preserve competition in the market, therefore such dominant players are subject to specific stricter rules when it comes to using all options to compete. So they cannot compete as all the others do in the market, but they have to take account of the fact that there is a limited amount of competition in the market, and their responsibility is to maintain it to the extent that it's beneficial to the consumers. This kind of rules on fairness therefore apply only to very big players, Google, Microsoft in the market, but not to smaller intermediation platforms. The category which was applied here mainly, there are various groups of limitation, case groups of limitations to the abuse of dominant position was mainly the tying abuse. Tying in cases where the dominant player also had not only a stronghold in the platform market, but also was offering the goods and services in the adjacent input market, and was tying the two together. I will just mention two examples very quickly. So in the Microsoft case of 2004, which is the mother of all competition cases with regard to fairness in the IT industry, the tying took place between the Windows Media Player and the Windows operating system. Microsoft was dominant in the Windows operating system market and had no stronghold in the media player market. And what they did, they just simply tied the media player to their operating system. And they couldn't so that you couldn't get a Windows operating system without media player, and this resulted in them gaining quickly higher market shares in the media player, adjacent media player market. The Google cases, which are more recent, are similar cases in terms of also relying on tying. One was about the Google Android operating system that is sold with a pre-installation of the Chrome browser. Again, I mean, this was seen as an abuse of dominant position, and a cease and desist order was imposed on Microsoft, together with a 4 billion euro fine. Another case was also against Google, which promoted its what we call vertical search services. So services, for instance, for restaurants or products, comparison, I mean, price comparison sites, promoted them by making them the algorithm, promoting them in the algorithm to come further up on page 1 as a result. And another case was also against Google, promoted its that was equally seen as an abuse of dominant position. And Google was also ordered to cease and desist such promotion. Many issues of algorithm confidentiality, IP rights arose during that case, but we can come back to that if there are questions later on. Page 1 as a result. I see time is flying, so I will quickly refer just to the safe harbor rule of the year 2000 and the cases that I was mentioning earlier. And I'm set here that you can't hear me. I can't see you and you can't hear me, it seems.
It's all right on our side.
I can't see anything. Can you hear me?
Everything is all right on our side, so you are free to carry on if you want.
I can't see anything.
Can you hear me? Yep.
Well, is there any? Can you hear me? I can't see you and I can't hear anything. Okay. So I relate back to the safe harbor rules.
Yes, well, I think we're going to ask questions. My first question is for Professor Van Gisegem. So that was a very interesting presentation. I would just like to hear your opinion about the consent of the patient. So from the perspective of the patient, what happens if someone refuses to be monitored remotely? Is there a room, for instance, under Article 3 of the European Convention of Human Rights, to refuse to be monitored remotely, to undergo acts on a remote basis? Is there a room to impose this kind of monitoring? What's about the patient's will in this framework? Yes, did you get my question, or? And then my second question was for Maître Chabert. So from a market perspective, so do you think that those tools that are conceived by lawyers will have more success? Like, is it something like new lawyers want to acquire these kind of products? Will they be more interested in products that are conceived by other lawyers, or is it something that they won't check before purchasing the products?
It's a very good question, because to be sure that those products will be efficient and will be more efficient for the other lawyer or for citizens, we have to work with other professionals. I mean, we have to conceive those algorithms and those new tools with other professionals. And I'm happy about this question, because it's a way to tell you that from now and until the end of the world, we need to work with other people. We need lawyers. Lawyers used to work alone and used to practice law on their side. And with those new tools, we have to work with other professionals, no-law professionals, to be sure that the tools we are implementing, we are conceiving with those professionals, are the right tools, not only from a law side, but also from a practical side. So that means that that lead the lawyer I was talking about, who created some legal text, that lead those guys, those lawyers, to create those legal text with other professionals, with IT professionals, with marketing professionals, to be sure that the product is answering a need of the market. And this is a new way to practice law, because we have to be inside the market to find solutions, to find tools which are very close to the needs of the citizen.
I mean, will those technologies be affordable? Or like if you're a young lawyer and you just started your business?
And for sure, those technologies will be affordable. And one of the goal of the Bar Association is to make possible the lawyer which are working alone on their own law firm to be able to have access to those new tools. So we are concluding some partnership with those companies, with those legal tech, to be able to, the Bar Association is concluding those partnerships, to be able to provide all the lawyers of the Bar Association those tools. And I just want to make a parallel with the way we created in the past, 30 years ago, a library. And it was very expensive to have its own library in its law firm. So the Bar Association created a common library. And this is exactly the same with these new tools. We are concluding partnership to be able to provide those tools to the entire Bar Association.
I think we're running out of time, so I will probably give the floor to Marjolaine Monod-Foutier for the conclusions.
So thank you, Thibault. Unfortunately, we can't have Corneliu Oldmer with us. We have lost the connection, I think. So we have reached the end of our works. These legal, technical, social issues linked to the arrival of artificial intelligence in our everyday lives. I'd like to thank you all for the richness of your contributions and for the relevance of the questions, even if we couldn't deal with all of them. I hope that this dissemination event convinced both academics, practitioners, and students of the interest and potential of our prospective legal clinic method. Do not hesitate to follow our program soon on our official website, Tech Law Clinics. And now the meeting is closed, and I wish you a good weekend. Bye-bye.